Welcome back to the Senior Hour. I'm Barbara Cochran with my co-host, Dr. Jean Doriot, on your hometown station, AM 1220 KHTS. And we're speaking with Randall Caden, who is an elder law attorney, and we're going through top 10 estate planning mistakes. And we've hit on 4 very important ones. So let's continue.
All right.
We want to get the other 6 in.
Yeah, so number 6 is, we see often, is not protecting yourself or your loved ones from what we call creditors and predators. Mm-hmm. When it comes to yourself, a lot of people are interested in asset protection, and especially when we're talking about seniors, it's so very important to have asset protection in both the MEDI-CAL and VA worlds. So you want to be able to create an asset protection trust to protect those assets from being eaten up. And if you can't do it, by the way, this goes back towards our mistake number 7, which is you want to have an elder law financial power of attorney. So if you're not able to create the asset protection trust, your agent can do it for you. So very, very important there to protect the assets for yourself. And the flip side of the coin on that is, after you're gone, is you want a plan that protects your loved ones. Now, it's obvious if you have a minor, you don't want them accruing to a lot of money. First of all, it's going to cause a guardianship, but beyond that, kids are going to spend money in kind of crazy ways. But so we usually will have a minimum age where they will inherit it outright, and before that, they would get it for healthcare, education, support, and maintenance. Now, also, though, even when kids are older, there's several examples where you really want to make sure that they're protected from creditors and predators. Some of the more obvious ones is if you have a child who has special needs and they're receiving SSI, you don't want them to lose out on that government benefit, so you want to have a special needs trust in place for them. Mm-hmm. Or maybe you have a child who's a spendthrift who just goes through money like water, and you want to protect them from themselves and have that available for them and their families, perhaps for a lifetime. Another one that we see very commonly is, let's say there's a daughter and she has a spouse that pressures her into spending a lot of money. And if she were to receive an inheritance outright, you can pretty much imagine how her husband in that situation might pressure her and say, hey, let's just take $50,000 here, let's take $50,000 there, and pretty soon all the money is gone. So we've frankly had spouses come back and thank us later on saying, that is so great that you set that up with my parents, because I wouldn't have known what to say. I can't resist the pressure. It's too much for me. And beyond that, of course, any beneficiary can be sued at any time for any reason. The most common ones are divorcing spouses. Unfortunately, we have a high divorce rate. We also see lawsuits between business partners, but it comes up in a lot of contexts. Perhaps a bad car accident. We just had the real estate crash. A lot of people went through foreclosure. Creditors are out there in all shapes, forms, and sizes. And if you want your kids to be protected, you want to set up the right kind of provisions in your trust to provide that asset protection. Okay? Which brings us to number 5. The 5th biggest mistake, estate planning mistake, is that we see is not keeping your documents updated to reflect changes in your life. Okay. Right. Now, common examples of that is, you see somebody, they've gotten divorced, or maybe they're now a widow, or they're remarried. With these changes, you clearly need to change your plan, or else you're going to create accidental distributions. We see that all the time, and it's really sad. Because a person didn't remember to change their trust after, for example, they got a divorce, the trust says everything goes to their ex-spouse and not to their kids. Or perhaps they've not updated their trust. They had a child or a new grandchild, and their trust said, I leave it to these grandchildren, and they accidentally leave out that last grandchild, something like that. So we have accidental distributions happening when people are not keeping on top of their estate planning. So anytime there's a change in your life, you definitely want to call your estate planning attorney and just make sure that there's nothing that needs to be changed. And also, you want to make sure with those changes that, a very common mistake we see is people will refinance their house. And when you do that, you generally have to take your house out of your trust because the bank wants to have a direct line to you and make the lien out to you. And so the people take the house out of their trust, and then they forget to put the house back into their trust. Oh, this is a big one, because then that would cause them to go into a probate court proceeding. And again, we're at the expense of an unnecessary probate proceeding. If the trust is drawn correctly, we can go through a lesser proceeding than a probate proceeding. It's called a 17-200 petition, or sometimes known as a Hagstead petition. But still, you're unnecessarily going to court, and we might not have the right beneficiaries again. So you absolutely want to make sure when there's changes in your life that you want to update your estate planning, which brings us to number 4, is also if there's changes in the law, you want to update your documents to reflect the changes in the law. And you may not even be aware of the changes in the law, and that's why you want to, with us, we have our clients come back into the office every 3 years for free and just say, let's just go through things and make sure that it's still everything is the way you want it to be. And, everybody should know that over the past 10 years, there's been really big changes in the law, and there's been drastic changes in the way trusts are actually drafted. For example, trusts nowadays, in comparison to, let's say, 10 years ago, modern trusts will have MEDI-CAL, or Veterans Aid and Attendance Planning language in the document that allows for that kind of planning. And if your trust doesn't have that, it's going to be a lot harder for you to do the planning that you need should you need government benefits as a senior for long-term care planning. Also, 10 years ago, when we had a retirement plan, generally people would leave their retirement plan first to a spouse and then maybe to their kids, and that can be okay in certain circumstances. In other circumstances, we set up a retirement trust, but if you didn't do that, at a minimum, if you want to make sure that your retirement accounts are going to the right people, then you can leave it as a contingent beneficiary. You can leave your living trust. But in order to do that, you need to have what's called conduit provisions in the living trust to prevent that retirement plan from being forced to have to pay out all of the proceeds in that retirement plan and having to pay a lot in taxes all of a sudden really quickly. So
it gets complicated too, so you have to know the left and the right way to go.
Yeah, so you absolutely want to coordinate your retirement plans with your living trust. And this is a shock to a lot of people, because for a long time they've heard that you can't leave a retirement plan to a living trust, and that's absolutely not true. You just have to have the right provisions. Another provision that you need to really think about having in your trust, if you have any kind of asset protection planning in there, is you want to have a trust protector. And the trust protector is somebody who's kind of similar to a trustee, but they act more like a judge. So there's someone that you trust in case your trustees are fighting, for example, and they can come in and they can be the tiebreaker with your trustees, so they don't have to go to court and litigate over your trust. They're a safety precaution. They also have the ability to amend the trust to comply with the law. They don't amend the trust to change the dispositive provisions under the trust, but they can amend the trust so that it complies with the law, so you don't have to go to court. They can do lots of things to really help out, but only if necessary. And so it's a little checks and balances on the trust that we never saw really 10, 20 years ago, that really people need to think about if they want to keep their trust out of court if there's any kind of issue or problem that arises in the future.
But trust protectors have to be legally savvy to all the ins and outs of the laws, or could they be a family member?
They can be a family member. Sometimes we actually don't even name a trust protector. We just put in a mechanism in the trust to name a trust protector later on in case a problem arises, so that we can avoid having to go to court.
Yes. Okay.
Another really, really big one is what we call a distribution trustee. So if we know that we have problem beneficiaries, problem children, maybe they have problems with drugs or any issue really underneath the sun, they're being sued. We have a distribution trustee that makes it impossible for another court to order the trustee of the trust to distribute out funds. So it is necessary in order to have full asset protection in the state of California. Okay, so that just is some examples of changes in the law that have occurred, and also kind of helps to reiterate mistake number 8, which is that all living trusts are not the same. It's definitely not true. There's all sorts of living trusts, and you really want the one that's right for you. And if we go to biggest mistake number 3, that's also exemplifies a different kind of trust, a very, very common trust. I would venture to say that most married couples who created a trust over 10 years ago, 8 years ago was really the triggering time because that's when the laws really changed. But back in the 2000s or 1990s, married couples commonly created what's called an AB or ABC trust. And they did that because the estate taxes were so high. And each spouse, the husband and wife, in the past, they would get an exclusion. When I started practicing 20 years ago, it was $600,000 per person. And so that would be $1.2 million that they could preclude from taxes. And the transfer tax system is the opposite of what people normally think. They think of income taxes. When I receive money, I have to pay taxes. The transfer tax system is actually the opposite. It says if I want to give away money, I have to pay taxes. And so because that number was relatively low, especially for Californians, and you could hit that number just with your real estate, people would set up AB trusts. So in other words, if they didn't do that planning, what would happen is one spouse would pass away, everything would go over to the surviving spouse, and there'd be no taxes. But at the death of the surviving spouse, there would be an unnecessary amount of taxes to be paid. Now, these days, we have the new Tax Act, which allows a married couple essentially $11 million to transfer to their beneficiaries without having to face any transfer taxes. So with $11 million, we know that 99.9% of society has less than that amount. We also have what's called portability, so that a surviving spouse, can just elect on a tax return to use their deceased spouse's exemption amount to get them to that $11 million. So the point is you don't need that AB or ABC trust anymore if that planning, the reason for that planning was simply for tax avoidance. And you really, really want to update the trust to make it a more simple trust. You want to go with KISS theory because it avoids having to pay accounting fees every single year on that bypass trust. It also avoids complicated administration at the death of the first spouse. And probably the worst part about it of all, and this is the one that totally escapes people, is that when you have an AB trust, you're actually, at the death of the first spouse, you're dividing up the estate, and you're putting half of it in the trust for the deceased spouse and half of it in the trust for the surviving spouse. And the half that's in the trust for a deceased spouse, it, over time, invariably, the assets in there, they appreciate. And all that appreciation, when it's in the bypass trust, is going to have to face income taxes.
Capital gains?
Capital gains income taxes. But if you have a simple trust, no, I'm not kidding at all, and I see this all the time, hundreds of thousands of dollars lost, because let's say somebody put a property or stocks in that bypass trust, and many, many years went by, and now we're 10 years down the line, and the second spouse passes away, and there's an inherent tax, federal state capital gains tax of about a third. Wow. And so if you just had a simple trust, we would have gotten a full step up in tax basis. Really, the only benefit to passing away in the United States is that step up in tax basis. It means that all the assets that you own when you pass away that are in your name, they will be stepped up to full fair market value, and they can be sold the very next day 100% tax-free. But if you had it in that AB trust, you don't get that. And incidentally, for those listeners out there who have had a spouse already pass away and they had an AB trust and they are hearing this and getting nervous, they really need to contact their estate planning attorney, and because we can go to court under certain proceedings and get a modification of that trust to dissolve it. But after both spouses are gone, then there is no way to do anything about it, and you're stuck with those, tens of thousands, if not hundreds of thousands of dollars in extra tax, which could have been totally avoided had you just updated your trust and made it more simple. So that's number 3. Now we're getting down to the nitty-gritty here. Number 2, the second biggest mistake, and this is for seniors, is really when they did their estate planning, they didn't create a life care plan. And what do I mean by that? Well, a life care plan addresses the issues seniors face with their medical issues, their housing issues, their financial issues, and their legal needs. So it's holistically looking at the big picture and saying, okay, let's figure out, based on your particular circumstances, your income, your expenses, your health condition, where you want to live, your assets, your liabilities, how are we going to structure things so that you can live life the way you want to live for the rest of your life without going broke, frankly, and without being put in an emergency situation. And, most seniors' estate plans only address the legal issues of what happens when I die. And, of course, that's a big thing to ask and answer, but in my opinion, it's a huge mistake if you're a senior and you're not looking at the other 4 quadrants. You want to do the life care planning, because to me, what overshadows the death planning is the life planning. It's far more important that adequate solutions are found so that seniors can live the life that they want to live, and they don't have to ask these questions. I get questions from seniors all the time about, where will they live? Will the government help them? How can they live the way they want to and not the way they're told to? Will they have enough resources out there? A life care plan solves all these issues by addressing all of them in advance and making sure that there's a plan in place. Without a plan, what's the saying? You're planning to fail. So that's the second biggest mistake, I'd say, that people make when they create estate planning.
So here's a question that our seniors are saying, okay, I want to plan this, and I'm now 82 years old, but I don't know how long I'm going to live. I don't know, and because I don't, am I going to live to 83 or am I going to live to 103?
Yes.
Trying to spread that out and figure out what assets you do need to live the way you want to live. I mean, I think some of that, that's juggling a lot of dollar signs and trying to figure out the direction you can go and how well you can live. The best thing is to have 10 children and just make sure that, they're all around when you're 82 years old and they can take care of you.
Yeah, I mean, if that's possible, I'm yet to meet the family that has had 10 kids come in and help out, but I think that
how do you that's what our seniors are saying. I don't know how long I'm going to live. How can I plan
so nobody
without knowing? Patients come in the hospital and you've got this. I'm going to give you antibiotics, and I'll have you out of here in 3 or 4 days, and I can give them their plan. But and you don't know how long you're going to live. That's a huge problem, isn't it?
It's a huge problem, and
it's the biggest problem. Actually, it should go number 1A on our list here.
Right.
It's not a mistake. It's just not knowing.
It's not knowing. But here's the thing. It's analogous to insurance in a way, because why do you buy insurance for your house if your house burns down? I mean, theoretically, if you really think about it, the chances of your house burning down are pretty slim and none. But if it does burn down, it's so catastrophic that you get insurance on your house. The same thing for your health care, the same thing for your automobile insurance, all these kinds of insurance. You really want to have insurance in place when the result if you didn't have insurance would be totally catastrophic. And this is the same kind of ideology. It is true that a person could set up a life care plan and do all this intricate elder law planning, and they might pass away a year later, and so they didn't get what we say in the law as the benefit of the bargain. They didn't really get that benefit of all that planning. However, it's not really a huge loss because it's not a big deal in a sense. It's like having the insurance on your home. If you really don't want your house to burn down. Actually, you don't want to have to use that insurance. Mm-hmm. But in this situation, if you do live to 103 and you do have another 20 years, it's a very realistic and important question to ask and answer to see how are you going to do it.
The insurances, and I don't know, with some of them, sometimes the premiums go up too high and you have to relinquish it, and sometimes you do have to use it, but then the fine lines and reading between the lines remove it because you're not eligible, even though you've been paying for 50 years. So all our seniors are sitting there going, okay, I can get insurance, but I'm not sure if I'll be able to use that or not. I mean,
by the way, in the life care planning context, if a person needs veterans aid and attendance pension benefits or MEDI-CAL, in other words, they're already there where they need it, it's a no-brainer because we know that we can get the benefits right now, and that can easily exceed the legal fees and the accounting fees to set up this kind of plan. And in fact, if people live 20 years, we're talking about potentially hundreds of thousands, if not millions of dollars that they saved and were able to capitalize on because they did this kind of planning.
And that's what I want to hear. That's where you've incorporated now for our listeners who are saying, oh, okay, I know how much I might need, but because it's out there and I don't know, then we have to fold in the possibility that I'll have to get insurance, so-called VA or MEDI-CAL or whatever it is, and assure that I can continue.
Right. It's 100% true.
Okay,
and our clients that have done it say, thank goodness we did it. I mean, this was a godsend for us, and there's no kind of return on investment like life care planning. If and when you need it, it is the best investment you could ever make. Period.
So we're going to take another break, but we're down to number one. I think the biggest, maybe not the biggest mistake, because I'll tell you, some of these of the 10 are big mistakes.
Yep.
So we're talking with Randall Caden, who's an elder law attorney, but it's such an interesting conversation. We're going to take a break. I'm Dr. Gene Dorio with my co-host Barbara Cochran on your hometown station AM 1220 KHTS.
Back to the Senior Hour. I'm Barbara Cochran with my co-host, Dr. Gene Dorio, on your hometown station, AM 1220 KHTS. And we're speaking with Randall Caden, an elder law attorney, and boy, have we learned a lot. And we have one more area to match up, and then overall.
And scare our listeners.
Yes. So the biggest mistake, in my opinion, is the most insidious mistake of all. And to really understand it, I'd like to give a couple minutes of background here. In the 90s, when I started practicing, almost all estate planning attorneys had their master's in tax because it was so tax heavy, the planning. And so there was a certain quality that went into the drafting of documents. You really only had tax attorneys creating estate plans. And when I would review estate plans back in the 90s, they were pretty impressive. They were pretty good. And then the 2000s happened, and the estate tax exemption started going higher and higher and higher. And as that occurred, at the same time, what happened is we had things like LegalZoom born, or We the People, paralegal services and such. And the quality of those documents were really quite terrible at the beginning. And it was still much better to go see an attorney. And some of my colleagues are not going to be happy about what I'm about to say, but I think it's absolutely true, is that over the last 10 or 15 years, what's happened is that the quality of even a LegalZoom kind of trust has gone up, even though it's very narrow. And what I've started to see in the last 5 or 10 years when I review trusts, if it was done by an attorney that was a jack of all trades, unfortunately, what I oftentimes find is that people would have been better off either doing nothing or going to even a LegalZoom, because that trust that was created by somebody who's a jack of all trades, unfortunately, there's a lot of conflicting provisions in them. There's a lot of problems, too many even to outline here, that I see. Let's say about 90% of the time. 10% of the time I see trusts that are great. 90% of the time I see them where they could have been done better, or possibly they're just completely terrible, and that's the worst thing to see. And so that really brings up the biggest mistake that people can make, in my opinion, which is they go and actually do this exercise. They create the estate plan, they do the elder law planning, but they do it with an inexperienced attorney, or an attorney who doesn't specialize specifically in estate planning, elder law, and administration of estates. And so what happens is the people walk away thinking that they've done the right thing, and they've paid good money to set up the right thing, and unfortunately it doesn't do what they want it to do, and so it doesn't transfer their estate in the manner that they want it. If they're alive and their kids want to do the elder law planning, they're not able to do that. And a lot of times we get a lot of clients that come in and ask us what to do, and sometimes we can't even do anything to fix it. So really, the family suffers irreparable harm. You want to make sure you have a good plan in place. Mm-hmm. And it's just like everything else these days. If you have a heart problem, you go see a heart doctor. If you have a specific issue, even you could be a mechanic, but you only work on Toyotas, for example. You may not know the first thing about fixing a Ford car. Mm-hmm. So my point is that you want somebody who specifically is only dealing with estate planning and elder law to create your planning. And that way you know that you're going to get a good plan. If you're going to somebody who's a jack of all trades, I hate to say it, but I probably would tell people, use LegalZoom.
Yeah. Well, as a physician, I'm a jack of all trades, but I sure know when to punt. And, nowadays medicine gets really complicated, and, law is complicated too, and elder law it's a complicated issue. You're going to have things that you don't want down the line that if you don't know about, your family's going to suffer. So I think that our listeners, are, who heard the 10 big mistakes here, Randall, I think this has just been a great asset for the community to hear what you're saying. And, I practice preventive medicine, and you're practicing preventive law and end-of-life care. Right. So I think it's important that our listeners hear that at this point. I mean, just great information, super information. Now, if people want to get a hold, where is your office here in San Diego?
It's in Valencia.
Yeah, where in Valencia?
Off of the old road, just by the 126.
Okay. Yeah. And then, so if they want to get a hold of you, Randall, how do they get a hold of you?
You can call our office at 661-247-8433. And I hope I didn't scare people too much, but it's really important for people to know the facts and make sure everything is up to date. And really, there's no reason to not make sure, because initial consultations are free. And,
you presented the facts, but you presented also the consequences, and I think that's the important thing that our listeners need to know about that. You might know everything, but if you don't know the direction to go, you don't want yourself and your family to be in trouble. Randall, thank you for being on the show today. Once again,
thank you for having me.
Randall Caden, his phone number is 247-8433 here in Valencia. Just great information. Thanks for being here today.
Thank you.
We appreciate it. We are sponsored by Advanced Audiology and Comfort Keepers in Home Care. Listen to us next week on the Senior Hour. Go enhance your quality of life.